recording, if I've done that right. And I do want to draw attention, you know, so obviously the first slide is indicating we're looking at the judicial branch, but I picked a picture of the Supreme Court. Right.
I don't think the computer picture
Nature is the ultimate Supreme Court.
Nature is the Supreme
expiring
Court.
against me. So what I did is I picked a picture of the Supreme Court, and it has obviously this, you know, the architecture there is pretty impressive. Roman style kind of columns and these, I picked an angle here where you got to kind of, you know, gaze up at it against the backdrop of the sky. What you can't quite make out, why aren't you going to play mode, is what's chiseled into the, it's coming, what's chiseled into kind of the banner there, I suppose. This idea of equal justice under law. Now, here's why I think that's significant. There's a lot of democratic values that we could pick to enshrine. But in part, this idea of equality under the law, that's unique to the courts, right? We looked at the courts in their decisions with regards to civil liberties, you know, providing, you know, in that sense, equal protection for all. Really, again, as we're looking at the Supreme Court, they're looking at the law itself as opposed to kind of those criminal cases and deciding guilt and innocence. They're looking at the law, but they're still concerned with the equality that the law provides. So I thought that was a nice way to start off. My next slide looks funky on my screen. Let's see if it looks good up there. All right, we're okay. So where we start, we did this with all the branches, is kind of just getting into the Constitution and trying to get into the framers' head and understand what they intended with this branch. They're kind of like you. They you know, had a long constitutional convention. They're a little worn out, right? So they kind of, you know, mailed this one in maybe a little bit. Really what we talk about with the court is that it is included for symmetry. This kind of goes back to day one with us, right? A triangle needs three sides. You cannot have an effective system of checks and balances if it's just two opposing branches. That's gridlock, right? You know, in some ways you make your system of checks and balances more complex if you include this third one. So it both might serve as a tiebreaker, but it also might serve as that additional safeguard. Do both those ideas make sense, right? So we set up the courts in Article 3, and what you see in Article 3 is really like 3.5 sections, and in those 3.5 sections they're going to set up the tenure, the jurisdiction, the number of justices, and they're going to basically leave the rest to Congress. The idea of the structure, jurisdiction of the inferior courts, that's somebody else's problem. So we're going to just set up the basics of a Supreme Court. That's one way to kind of see that they've included it just for symmetry, the lack of detail in the Constitution. And we'll look at those 3.5 things in a little more detail here in a second. Another thing to look at is the fact that the court didn't have a home. That ought to say something, right? We've created this third branch of government. Where's it going to kind of like, you know, where's its office? What now?
Basement.
Yeah, they basically didn't even have one at first. And what they'll resort to is things like basements. So at first, they just kind of find office space. You know, it's a kind of, you know, picture like an open air market, almost like Faneuil Hall, but it's there's buildings that kind of create this courtyard, and above the courtyard is a second story, and that's, you know, the courts find basically kind of office space there, overlooking a meat market for all intents and purposes. That's where they start.
Yeah, like in the reading it says that, you know, they were paid so little that one Supreme Court justice pieces out and joins the South Carolina State Supreme Court.
Yeah.
That state was paying more.
We'll talk about John Jay, who, you know, is the first Supreme Court justice, and you would think that's really prestigious, and he says, to heck with this. It's not just the pay too, it's this, the rigors of the Supreme Court involved for having to ride circuit. We'll talk about that in a second, but they had to go visit the other courts to supervise them, and that's by carriage. So no pay, no prestige, no home. Why would you want this job, right? So eventually, as the capital moves, so does the court. They're going to move from New York City to Philadelphia and eventually to Washington. And they're building the Capitol, right? As they build the Capitol, it's still like, oh yeah, we don't have a place for you. And that's where the basement part you mentioned comes in. At first, they're in essentially a House committee room. And eventually, they give them a place in the Senate, but it's kind of subterranean. If you've been to the Capitol, you can go see it still. You basically go down kind of a spiral staircase, and you know, believe me, all floors are kind of impressive, and the room is somewhat impressive, I suppose, but it's a little claustrophobic, and you literally are kind of, like, to look at this, you're peeking your head around the corner to see it. So this is, you know, its original setting. It's Taft, and again, Taft's a kind of a fascinating figure who is tapped to be the president after Roosevelt, Teddy, but a reluctant, you know, person to, you know, he basically sits down with Roosevelt, and his wife is there as well, and Roosevelt is debating, it's either the presidency for you or the Supreme Court, and Taft wants the Supreme Court. I think he's just got this legal mind, and loved the idea of being on the Supreme Court. His wife, in particular, wanted him to be president, and then when Roosevelt saw what he did, had the Bull Moose Party, right? So poor Taft is, you know, forced into a job he doesn't like, and then you know, Roosevelt kicks him in the teeth for it. Eventually, he's going to become a Supreme Court justice. Kind of a wild pathway to think about, going from president to Supreme Court justice. But he's able to kind of, you know, use that future ambition, I think, for the Supreme Court to get the ball rolling on a permanent home. It looks like that, and you can go visit it. So you can also see them in session. You've got to really time it. Those are hot tickets to get. But, you know, they do have open sessions, and you can kind of, you know, they are open to the public if you, you know, get there on time. You're gonna line, sometimes, like, I watch people line up, like, it was like they're lining up for, like, you know, a rock concert. They're there overnight, right? So, okay, the lack of detail, how come? Well, we've been over this as well. This is the least feared of the three branches, and you go back to Federalist 78, where they talk about it not having either the sword or the purse. The sword is which of the two branches?
Executive.
The executive. The purse, the legislature, right? I mean, that's the power to, like, the law doesn't have much of an impact unless you fund it. So they talk about it not having either of those things. It has neither force nor will. All it has is judgment. And ultimately, you know, go back to Andrew Jackson and that kind of, you gotta scrutinize whether he actually said it this way, but the idea of, I didn't like Chisholm versus Georgia, right? The court has made its decision.
Now let them enforce
Now
it.
let
I
them
almost
enforce it.
quoted that in my.
In your essay?
Yeah, I
So,
almost did.
good. So, I mean, there's points where those things kind of fit, right? So, you know, the idea is all they have is judgment, and it doesn't matter if there isn't someone to enforce it. The other branches, there's the implementing population of the states and the people. We don't have to worry about this branch too much. At this point, it's only going to be 5 guys in robes, right? So what we're going to see over time, though, is how incredibly critical this branch is. And ultimately, this is kind of underserved here, where I'm talking about you need an arbiter to kind of figure out what the Constitution means relative to state and federal laws. Well, that's not just it. Think about any point where you could have controversy, right? It could be between the Constitution and federal law, like we passed a new law and it seems to be contrary to the Constitution. It could be citizens and the Constitution. It could be the other branches, something the you know, legislative or executive branch did in the Constitution. It could be states, and kind of state law, state actions. It could be foreign governments and foreign parties. There's a lot of points where, like, hey, there's controversies to sort out. So not only is there a tremendous need for it, but that need means the court will rise in stature, and in a lot of ways the vague language gives them a lot of latitude, okay? So seeing that it becomes such an important branch, we obviously want to do a deeper dive on it. We're going to get into kind of the language of the Constitution. There's 3.5 sections really to look at. It starts in Article 3, Section 1, where we're going to define up the power, the structure, and tenure in the following, like, 3 lines, and I've just kind of clipped them. You know, they're annotated here. So what it says about their power is that they have judicial power, okay? And it's vested in one Supreme Court, all right? So, I mean, there's some vague language, and we'll figure out what judicial power means really as we go along. It's the idea to kind of decide all cases in law and equity, hence, again, the banner up above the Supreme Court. And what are we doing with the lower courts? We're leaving it for Congress to time and time ordain and establish. We don't even have a timetable. We don't even have kind of like, well, how many courts? how many levels, those kind of things. Really, it's up to you, Congress, later on. The other thing that we're gonna do in terms of establishing structure and powers, we're gonna grant justices lifetime tenure pending good behavior. Now, both of those are kind of important, because again, if justices get in as part of the appointment process, obviously politics will play a role. The politics of the president, the power of, who's got the power of advice and consent? Senate, right? So those two, groups will obviously have a sway on, arguably what should matter. Should it matter the politics of the justice? It used to not. We're gonna read about Bork and kind of the abortion issue and how that came to the forefront. But traditionally, you just looked at, are they well qualified? You might look at their judicial philosophy. How did they kind of look at their role? That's important. Politics really arguably wouldn't play a role, but it certainly does today. And that's gonna shape them. And the concern is, are they gonna be acting independently if you are beholden to somebody else, including voters? There's some states that, for their state Supreme Court or other judicial positions, you run for it. That's interesting to think about the courts as being more responsible to constituencies. And do you want that or not? There's people that rail against the court as unelected officials who preside for life and they just kind of legislate from the bench. On the other hand, it might be nice to have a branch that is separate from mob passion and can rule according to the law. So at any rate, there's a lot in here to kind of think about. And the point too is that they're not completely able to go off the rails because you do have the impeachment option. That good behavior suggests they can be impeached, right? Again, we're all kinds of concerned throughout the document about financial blackmail. Nothing in the news to see about that. We're really concerned about financial blackmail and the use of salary to kind of blackmail somebody, to say, hey, I didn't like that ruling, so I guess I'm gonna drop your salary. So you can, I suppose, drop their salary, but not during their tenure. And since they're there forever, Ruth Bader Ginsburg being a great example, right? That's gonna be hard to move. Now,
The notorious.
Section 2, notorious
Notorious
RPG.
RPG.
So Section 2 sets up their jurisdiction, and that's a key term that you ought to know. That's the authority to hear a specific kind of case. So, for example, let's make it real simple, like family court. They have a specific jurisdiction. They have authority to hear cases involving child custody or maybe cases of child endangerment, those kind of things, right? There's other kinds of specific courts that you might be familiar with, that you might have to go to traffic court if you got a particular ticket and you were looking to contest it, okay? So the jurisdiction is the authority to hear a specific kind of case, and their jurisdiction needs to be spelled out. So like again, I said, in general, what they have is the power to decide all cases in law and equity. And as I suggested earlier, holy cow, that's a big arrangement of things. That could be between the Constitution and laws, state actions, treaties, controversies between two states, controversies between a state and citizen. There's a lot of ways that you can kind of combine up, cases involving law and equity. What's, I don't know if it's more interesting, but what's kind of, I guess to make it more complicated, just keep in mind, and we've talked about a little bit of this with Marbury versus Madison, jurisdiction is just a generic term. There's more formally original jurisdiction and appellate jurisdiction. Do you remember original jurisdiction? What does that mean?
It's like the power of the court to hear the case first.
First, right. So this case goes right to that court without cross and go. We go to it right away. Appellate, go ahead.
It's when people appeal the
Good.
case.
So, an appellate jurisdiction means someone else has already looked at the case and you're looking at it second or third or fourth, depending on how many appeals and levels that you can kind of imagine, right? So, you have to kind of think about it. This is just in general its jurisdiction. What is its original jurisdiction? What is its appellate jurisdiction? What would make sense in terms of a case going right to the Supreme Court? And again, Marbury versus Madison brought that up. What a case where government isn't doing its sworn kind of duties, where it's violating perhaps a You know, it's writ of mandamus. I almost said writs of assistance. That it's violating its kind of writ of mandamus. Is that supposed to go right to the Supreme Court? Eventually they're going to decide, no, that doesn't make sense. Someone else can look at that first. Why would we judge if what we as the federal government are doing is right away? That should be looked at somewhere else first, okay? So I'm going to show you in a second a chart that kind of spells it out, but if you were to guess how, you know, in terms of like, you know, the types of cases out there, what percent do you think are part of the appellate jurisdiction of the courts, and what percent of cases do you think are part of its original jurisdiction? Do you think like 50% of the time, you know, cases are part of original jurisdiction and 50% it's appellate?
90% original, 10% appellate.
Yeah, close. We're going to even less than that. It's like 97-3. So it's a real narrow kind of category that is going to spell out its original jurisdiction. That having been said, there is formal language to say what kind of cases are what. But keep in mind, a lot of times things are established by precedent and informally. So if you brought something to the Supreme Court and you skipped the other courts and they decided to take the case, that is now part of their original jurisdiction. So courts sometimes almost define up their own jurisdiction by by attorneys' decisions to file there and their decisions to take the cases, right? This is in your,
It's in our book.
yeah, I think it's in the continuity and, no, it's in it is in continuity and change. I've got a chart here that's in the other book. And you can kind of see, oh, my highlighting went away. That stinks. It gives you original jurisdiction and appellate jurisdiction. It will kind of spell out where, you know, the two sides are. And it's, you know, when there's two or more states, when the United States and a state have a controversy, when it involves a foreign country or diplomat, when it involves a state and a citizen. That's about it. And then 97 to 90% of the time, they're hearing a case second. Do you notice something else? So, and one of the things we're going to see is kind of the structure of our court system. It's obviously three-tiered. But do you notice something else with the numbers? And you can kind of see it here on the state side as well. What do you notice?
The district courts will hear much more.
Yeah, so my numbers are going down as I go up. We start with, you know, there's 94 district courts, and they hear over 250,000 cases a year. On the state side, 100 million.
Oh my God.
We are a litigious society, meaning when you look at this, a lot of this may be criminal in nature, but a lot of this is also civil in nature. We'll distinguish those terms. But we're really quick to use the courts as a remedy, right? And what's happening with those numbers as we go up is, obviously the numbers are going down. I don't know if that seems like a big number to you. You know, they decide less than 100 cases a year. We'll look into kind of the why in a little bit. But it's kind of, you know, the chart's good in that it gives you some of the ideas of the structure of how the court works. All right, so what else is left? Well, Section 3 defines treason, and that way we can figure out whether to impeach them. Within Article 1, Section 3, we're going to put the Chief Justice, there's Rehnquist with Strom Thurmond presiding over the Clinton impeachment case, you know, when it got to the Senate and there was going to be the trial. So that's about it, 3.5 sections. Where the rest of it gets detailed is in the Judiciary Act. So what you see here is where we set up that three-tier system. And I just kind of showed you the chart, but let's explain it a little more specifically. Down at the bottom are the district trial courts. Those are the kind of the initial courts that kind of try the case and establish the facts. You know, once you get the kind of facts, as you go to the courts of appeal and the Supreme Court, they're really looking at was the law applied correctly. They're not retrying the case. They're not reestablishing, you know, where a person was, whether or not they had a weapon, who the eyewitness was. They're just looking at kind of the law. So this is kind of where you start. This is where, you know, original jurisdiction exists in most cases, and this is where most cases end. And most of them end, if you got to guess, if anybody's been to the courts, does it end in the courtroom?
Plea bargaining
It usually ends in the hallway with plea bargaining, right? Because again, and this is, I kind of suggested this earlier, can you cry poverty as a way to kind of say, I can't afford to give people their constitutional rights in their day in court? it is hard for the courts to go through this volume, especially given the number of courts and justices and resources that they have. So really oftentimes they incentivize through sentencing and through how they do things to get you out in the hallways and settle it. It is one way to kind of resolve things. If it's done through kind of pressure of like the alternative is worse, I don't know if that's justice, but that's kind of how we operate.
Yeah, I remember like we went like last year at
Yeah.
Youth and Law. We went and saw like an actual like court case happen, and the guy, like people were like the justice, the judge,
Yeah.
seemed kind of shocked when the defendant wasn't going to plea bargain, and
Yeah.
it was even afterwards, like after they had left for like a break,
Right.
like for a recess, the lawyer for the defendant came over to us. He's like, "Yeah, my client's probably screwed, but what I'm trying to play off of is there was shoddy police work involved.
Yeah.
Like they didn't read him his rights and stuff.
Okay.
There were multiple cases that day too.
Yeah.
It wasn't just like one long case, it was like multiple happened just like that.
But a lot of them settle in the hallway. Yeah, it's kind of, so again, the numbers hide that. Now, Court of Appeals, we'll look at, they're originally referred to as circuit courts. So sometimes the language gets a little tricky, but we call them courts of appeal. They're that middle level. I'll show you in a second, there's like 13 of them. There's 12 geographically based ones, and I'll show you on a map in a while what that looks like. But you know, when you see the map later on, what you'll realize is that's like multi-state kind of districts that are set up, and the rulings of the appeals courts apply to all those states within that district. And then you've got the Supreme Court at the top. And again, the numbers kind of varied. At first it was, you know, we set the number at 6 and then eventually it comes up to 5. So, you know, here's another way to look at it. And again, it's got the numbers that I just mentioned. Their numbers are kind of fudged here because it's 13 Court of Appeals total. There's actually 11 geographic. There's one if you are, let's say you don't like the net neutrality ruling and you want to sue the FCC. There's a special court for that. Let's say there's a financial claim against, let's say the Department of Veterans Affairs because they have underserved veterans and not provided proper medical care. Let's say there's a suit against them. There's a special court for that. So there's 11 geographically based ones, and then these 2 special ones that deal with you know, regulatory kind of suits against the government and financial suits against the government. Okay, and then again, you work your way up to the Supreme Court. So I thought I had other pictures in here. I dropped some in, but I lost them. I'll come back to this one. It's a 3-tiered system, right? There's 3 tiers, but keep in mind there's also 3 tiers on the state side. So it's kind of a dual 3-tiered system that, you know, if you get on this side, do you have to stay in the state side? There may be a point where you decide to appeal, and often it's from you know, the Supreme Court of the state side, but cases sometimes have jumped from the state to the courts. And again, can you do that? Well, if the court decides to take it, yes. If your attorney decides to file and they take it, yes. So, at any rate, that's the basic structure, but in defining up the structure and who they are, you have to kind of look at the first series of justices who helped define the office. And the first one we mentioned already is John Jay. Recognize his name?
Yeah.
How do we know him? Jay's
He
Treaty.
got sick after writing 5.
There we go. He's one of the 3 authors of the Federalist Papers too. Don't forget, I mean, he's got this distinguished political career, including being a diplomat, but he's one of our Federalist Paper authors. And I mentioned it already, the lack of prestige, the lack of power and support caused him to resign. You know, he served under Washington. Adams asked for him back. Poor Adams, he's always getting kind of like, you know, knowing that he's second fiddle here. And he refuses. And a lot of it, like I said, had to do with like no home. They're not financially supported. They don't have a staff. There's no one's defined up the office. So fine, we kind of, you know, when you see that they, you're going to see that they, I think it's during the first 3 sessions, they didn't have any cases. And if they did, they didn't like, what do? Do we write it down? Do I kind of walk out to a window and yell? What's the procedure for kind of letting you know what we decided? What's its impact? But I think the worst part of it is riding circuit, because there are these appeals courts that are set up, these circuit courts, and you had to ride circuit by horseback. So I'm basically doing 2 jobs, and I'm doing all this travel for no pay and no prestige, and no real power. The heck with it. The only thing that I would credit the J Court with, here he is Washington. Again, Washington is kind of figuring out the job as well. So Washington kind of figures out, you know, for example, I'm supposed to, you know, negotiate treaties with the advice and consent of the Senate. But that doesn't mean I have to go to them on a daily basis. You know, a lot easier to ask for forgiveness than permission. Does that make sense? So I'm gonna negotiate first and then say, what do you think, second, right? Well, he goes to John Jay sometimes for legal advice. And John Jay basically kind of gives him, I suppose, that advice in reverse. We're not here as your legal counsel. You go ahead and, you know, act, and we'll decide afterwards. We're independent. So we're not the Justice Department. We are the Supreme Court. There is no Justice Department at that point. That's what eventually evolves to give the president legal advice, right? So there's the J Court. One of its most impactful and confusing decisions, because of the 11th Amendment that's coming, is Chisholm versus Georgia. Ring any bells? All right. So in this case, there's essentially a controversy between two states. It's really a state and a citizen from another state. So Georgia contracted to buy some things from a businessman in South Carolina. Yes, South Carolina. And then they didn't pay, right? They welched on it. They didn't pay. So they didn't pay, and he basically, a representative of him is going to, named Chisholm, is going to take this to court. And when you look at the Supreme Court, you look at its original jurisdiction, it has original jurisdiction over cases involving individuals of a different state and a state, right? That, I don't know, let's say you guys have an issue with me, right? And then I'm like, okay, you can come to my court of arbitration and I'll decide it. It's a little bit too much of a home court advantage, don't you think? For
Literal home court.
Yeah, pun intended, right? So does it seem to make sense that you know, you have to kind of challenge Georgia in Georgia's home court? So the Supreme Court said, no, look, in controversies involving individual states and citizens of other states, that's our jurisdiction. Citizens are sovereign, the states are not. On some level, this may make sense, but it also ought to make you uncomfortable. Because what it's saying is states are kind of, not dependents. They're not sovereign. If they're not sovereign, then they are answerable to the federal government. Is that totally consistent with the federal model? Not entirely, right? They're, you know, in many ways, they're, again, you've got the, not the 9th, but the 10th, right? That kind of suggests that they have these reserved powers, and these reserved powers are theirs that they keep.
Right.
We have the states as a check on the power of the federal government.
This kind of says no to that.
Right. So while the decision, I think, intellectually makes sense, from a structural standpoint, it may raise some issues. So what we pass is the 11th Amendment. All right, so we just did the 9th and the 10th. Here comes the 11th. And what it says is that we're going to change, essentially, the jurisdiction established in the Constitution. That your original jurisdiction, your judicial power, does not extend to suits involving citizens of one state versus another. Huh. Well, does that mean I'm never going to get a fair trial? If I'm, you know, this guy from North Carolina and Georgia ripped me off, there's no Georgia court that's ever going to give me my money back, right? This seems like, you know, I'm not going to you know, have any remedy. There are some, and we'll get to that in a second. But the logic here is you're not subordinates. I like this. You're virtual quasi-sovereign.
You're almost maybe.
Almost maybe
almost
sovereign,
maybe sovereign.
right? Virtual I mean, I've got 2 modifiers there, because you want to be careful how far you go. But on some level, I think it makes sense that, you know, you don't want to give them total dependency, but you can't give them total immunity. Does that make sense? Here's another way to look at it too. Do you think like foreign countries should be, like we do drone strikes? Should a foreign country be able to drag us into their courts and hold us accountable? Would we ever answer to that?
No.
If only there was some sort of neutral international court for war crimes.
I don't think they could think of that.
Yeah.
That would be.
But
But you get my idea. So, or let's say there's a trade dispute, right? Similarly, would you want a foreign court or a kind of a international court to have that jurisdiction over the United States? And the answer is probably no. Because that would, in many ways, compromise the sovereignty of the United States. Therefore, this should make sense if you think about it on the state level and understand what states represent, especially back then. People more had the idea of state citizenship than national citizenship, and it was a necessary check against the force of the federal government. But there are some checks, okay? So when, it sounds like if I'm making them virtual quasi kind of sovereign entities, there's never a moment where they're answerable to anybody but themselves. Not true. You can essentially not go after the state, but you can go after their officers. It's called the stripping doctrine. By definition, a state can't do anything unconstitutional. Therefore, if something unconstitutional has happened, someone has to be answerable to it. You know, an official is, you know, the one ultimately carrying out the policy. And they can't argue, well, I was doing it on behalf of the state, and therefore I have immunity. No, you don't, because the state, by definition, can't do anything unconstitutional. So if something unconstitutional happened, it's you. All right? So that's one way. Or you can say, well, I can't go after Georgia, but I can go after Atlanta. You can go after its subdivisions. So you can kind of figure out your way around that. It may be that the state waives its kind of constitutional immunity. It maybe wants the case settled somewhere else. Maybe because it's, you know, wanting an issue settled, or maybe it's because they see it as kind of, you know, there may be an optics to it. It might be because they see it in a procedural way is the right way to go about it. But really the way they're going to go around it, here it comes again, 14th Amendment, right? What's the beginning of the 14th Amendment? No state shall. So I can use the 14th Amendment. What I basically have to do is, you know, it's kind of, I've got to have legislation that, you know, sets it up so that I can use the 14th Amendment. So it's not just as easy as me kind of riding in all of a sudden out of left field applying the 14th Amendment and the Equal Protection and Due Process Clause. Whatever controversy I'm looking at, it has to have a law that opened the door for it in the first place.
So then why are there court cases called like Miranda v. Arizona or like Cherokee?
Because that's the
Starts with an I.
Incorporation.
Those are incorporation cases.
Okay.
Right. So, and I get what you're saying. This isn't necessarily where I'm dragging the state in. It does sound kind of similar, right? This is why it makes the 11th Amendment and all of this so kind of tricky. I am not claiming
We did it.
Yeah, it's essentially what I'm saying is I am using the 14th Amendment to do this, and that's why it's kind of consistent with, I've lost it again. It is consistent with this idea of the 14th Amendment. This is one of the ways around. But also what I'm doing is I'm using that appellate. I guess that's what makes it a little difference too, is that this is an appeals case, as opposed to I'm plucking the case and I'm deciding it before the state has an opportunity to kind of weigh in on it. And really because it's an incorporation case, it makes it a whole nother beast too. You know, the federal government is using its authority to kind of say that this is the application of federal law, as opposed to kind of coming in and saying, this contract was wrong, or you acted unconstitutionally in this way. So there's a number of tricky things that make it different, but you're right, in that we can kind of say like, why is this the exception? So I guess the quick answer is because of the 14th Amendment. Yeah, that's a good question. All right, so I don't have a ton of time, right? But what we're gonna do, you know, and I'll start it quickly and then we'll continue it on Monday, is we'll move now from the J Court to the Marshall Court. If you're gonna get asked about any Supreme Court justice, really it's Marshall, right? He is a giant. And it really comes down to like what are the two obvious cases? Marbury versus Madison, McCulloch versus Maryland, keep going. Givens versus Ogden, right? Fletcher versus Peck, Hunter versus Lisset, right? So these are all like the major cases that were decided while Marshall was there, and you almost want to look at them in sequence. But one of the things, and I think I mentioned it a little bit, one of the things that he does first and foremost though is he kind of changes the way in which they pass rulings. Before, literally, you could get, let's say, again, there's 6 justices at this point, 6 different verdicts for 6 different reasons. And they'd kind of throw them at you, and then it was up to you to decide what it all meant. And he realized there's no way we're ever gonna have standing if we do that. That we've gotta get rid of this practice of called seritem in a series. What do you think, what do you think, what do you think? And that we've gotta speak more unanimously. So he began, there are ways to kind of dissent, so there's different types of rulings, but he basically kind of got rid of the idea of like, you can't all speak as 6 different individuals. There can be a majority opinion and a minority opinion, although he often steered them well away from that too. He felt like they were much stronger when they were a unified voice. And you're gonna see there's actually cases where you can say, I'm with the majority but for a different reason, or I'm with the minority and for a different reason. But we want a more unified way of speaking, and especially as one. You know, what court case here that would have never held up if it wasn't unanimous? Brown v. Board, right? You're never going to be able to hold this up. Remember that the video did a nice job of it, because the dissenting opinion becomes what?
That waiting part for the.
Yeah, that it becomes that legal argument for the challenge that eventually makes that minority opinion tomorrow's majority opinion, right? So that's 1. 2, judicial review, Marbury versus Madison. Hopefully I don't have to go over that again, right?
Well, it's
You
not.
should again
That's
have
worse
that.
than Buckley Malaya.
You should have that tattooed, right? But what's the
Put it on my
significance
gravestone.
of, real quick, because we've been over this, what's the significance of Fletcher versus Peck and Martin versus Hunter? I'm taking judicial review and I'm applying it where?
States.
States, right? In Fletcher versus Peck, I'm applying it to the legislature. In Martin versus Hunter, I'm applying it to the courts, state courts. And we can go over the details of the cases a little bit more, but what makes this savvy? Marshall got judicial review, and then what was he smart about doing with it?
Not using it.
Not using it against
That's like
the federal government, right? Because that's gonna come back to kick him in his teeth. If he's going to use it, he sits on it for a while and eventually uses it against the states, all right? And slowly establishes it. Good.
Abby Roman